So, welcome and thank you for attending this continuing legal education program sponsored by the University of New Mexico School of Law and the Leifer Border Justice Initiative. The Leifer Border Justice Initiative is a project sponsored by the University of New Mexico School of Law and the Jacqueline Marie Leifer Foundation. Its mission is to address the ongoing humanitarian crisis at the border. Women, children, and families fleeing political and social persecution are being subjected to inhumane conditions and abuse as they seek a better life. This CLE will be recorded. Please turn off your video feed if you do not wish to be seen on the recording.
797017.
Please also mute your volume if not speaking. If you need help with getting your CLE certificate, please contact Cheryl Burbank at the address which will be added to the chat. If you need a copy of the PowerPoint, if you would like to volunteer with this project, or if you have any questions about the Leifer Border Justice Initiative, please contact Patrick Lopez, whose email address will be added to the chat. The presenters will have time for questions and answers at the end, so please type your questions in the chat. Today, we would like to welcome immigration attorneys Mary Kramer and Caitlin Ford, who will be speaking on marijuana-related activity and immigration consequences. A Miami immigration lawyer with over 20 years of experience, Mary Kramer has served as president of the South Florida chapter of the American Immigration Lawyers Association and the Board of Catholic Legal Services. She established a pro bono project serving South Florida's poor in deportation proceedings in immigration court, for which she was awarded the Florida Attorney General's Meritorious Public Service Award. Ms. Kramer has taught immigration law at Florida International University as an adjunct professor and clerk for the Miami and Harlingen, Texas immigration courts. She's the author of Immigration Consequences of Criminal Activity, a guide to representing foreign-born defendants, now in its 7th edition. Caitlin Ford has been practicing immigration law since 2013 and specializes in family and humanitarian-based immigration, removal defense, and post-conviction relief. She also practices criminal defense. Ms. Ford practices in immigration courts all over the country, including in El Paso, the 10th Circuit Court of Appeals, U.S. District Court for the District of New Mexico State Courts, U.S. Citizenship and Immigration Services, and all immigration-related agencies. Ms. Ford earned her JD from the University of New Mexico School of Law and graduated with honors from the University of Puget Sound with degrees in International Relations and Spanish. Welcome, Mary Kramer and Caitlin Ford.
Hi, thank you. Do you see me?
We do not see you and we do not see your slides either. I know you want to put them up.
So I cannot put the PowerPoint up. You want to try?
I can do it.
Hello, everyone.
Sorry, everybody. I'm used to using a different browser.
Just let me know when you want me to move forward, Mary. I got it.
Okay. And does it have to look like this with the whole?
No, she's doing it. Caitlin is doing the.
How do I
You're just-
share?
Oh, can you make it bigger? Or
It's
is
not
that
me,
just the way
it's
Chrome
Caitlin.
is?
There it
Okay.
is.
All right.
Is that what's
Thank
good?
you. Thank you, Caitlin.
Okay.
I have never had a smooth landing on Zoom yet, so I apologize. A couple weeks ago, I taught an entire, day-long conference sharing my screen, and this time it wanted me to switch over to Google Chrome, and then I couldn't do it. So it's actually not 20 years, everybody. It's 30 years, but only now getting up to date on Zoom. So hello, and thank you for joining us. Today, we are going to talk about sort of the interchange between the Immigration and Nationality Act and the treatment of marijuana convictions and offenses and violations with the context of the state of New Mexico. So, Caitlin, next screen. As you all know, many states have legalized recreational marijuana, and that includes states that have allowed for medical marijuana. Next screen. I have like this urge to come up and move the screen. But Caitlin, why don't you tell us what is the state of the law quickly in New Mexico?
So in New Mexico, as you guys know, we have had medical marijuana since 2007. We were the 12th state in the US to do so. Under our Compassionate Use Act, qualifying patients can possess up to 8 ounces of medical marijuana over a 90-day period. So that's a rolling period. They can purchase 8 ounces every 90 days. That period rolls forward. In July 2019, New Mexico decriminalized possession of small amounts of marijuana up to half an ounce. But we have not yet passed a full legalization measure. Governor Lujan has made this a priority and hopes to pass this bill next year in 2021. So as the law stands right now, if you have up to half an ounce, there is simply a $50 fine. It's like a parking ticket. As the amounts get greater and the offenses get greater, then you're looking at misdemeanors that have the possibility of incarceration or fines. You don't hit a felony until you get to more than 8 ounces.
All right, so drum roll, federal law. So set aside, compartmentalize, put in a shoebox, everything Caitlin just said about New Mexico law, because we're going to talk about federal law, which is different. Under the Controlled Substances Act, there is no medically justified use of marijuana. It is a controlled substance, I believe Schedule 1, yes, and it is treated and punished accordingly. So we really have night and day between New Mexico, many of the states, and federal law. Next slide. So for those of you who have already studied immigration law, know immigration law, you understand that there are different provisions, distinct provisions spread throughout the Immigration and Nationality Act that treat controlled substance violations. That includes, of course, marijuana. So there are different chapters, 2 different chapters that deal with removability for marijuana offenses. And the first one we're going to talk about is deportation, which is under Section 237 of the Immigration and Nationality Act. If you're looking at the 8 United States Code version, it's 1227, 8 USC 1227 A2B. Now, to be deportable, you have to already be in the United States, and you have to be physically present here following some sort of lawful admission. And a little bit further down the line, we're going to talk about the different chapter and the different posture that people are in. So 2 chapters, 1227 and 1182 of the United States Code. So to be deportable under Section 237, there is an exception for one offense, simple possession, less than 30 grams. There is an exception for simple personal possession, less than 30 grams. You have to have a, quote, conviction. And we're going to talk about what is a conviction. You might think, ladies and gentlemen, that you know what a conviction is, but when it comes to immigration, you may not know what a conviction is. The burden of proof in deportation, the burden of proof in removal proceedings is on the Department of Homeland Security. So that means the Department of Homeland Security needs to prove that you have a conviction and that it was more than 30 grams, all right? The amount takes a specific analysis that we call the circumstance-specific approach, which means that the Department of Homeland Security, in meeting their burden of proof, can introduce miscellaneous documents, relevant evidence, whatever is relevant evidence, to show that a particular marijuana offense involved more than 30 grams. Usually with immigration, we stick to the criminal statute, and sometimes we look at the actual record of conviction, the charging document, and the final judgment. But under a circumstance-specific approach, the government is allowed to look at a variety of documentation and present it to the immigration judge to prove the amount. So we're talking about removal proceedings and deportability. There has to be a final conviction, as that term is defined under the Immigration and Nationality Act, and the burden of proof is on the Department of Homeland Security. But in meeting that burden of proof, they can introduce all manner of documentation. It can be discovery materials, it can be the arrest report to prove that the conviction involved more than 30 grams. Next slide. So a heartbeat ago, I mentioned that you have to have a final conviction, as that term is defined under the Immigration and Nationality Act. What is a conviction is defined at 101A 48A. And I wanted to briefly turn it over to Caitlin to talk about citations and ordinance violations. And the case that you want to be looking at is matter of Cuellar Gomez. Not looking at right now, but that is the case that deals with minor violations, ordinance violations, municipal violations. Caitlin, is the next slide yours or mine?
Let's see here. This one's yours.
Oh, okay. So in 1 second, Caitlin is going to talk about New Mexico dispositions. But what is the burden of proof in removal proceedings? A conviction normally requires a beyond a reasonable doubt. In removal proceedings, it's clear and convincing and persuasive evidence. So can the disposition be used as a prior controlled substance? Oh, okay. I know what I'm remembering what I want to bring out with this slide. In looking at whether a certain violation or ordinance violation is going to qualify as a conviction, the Board of Immigration Appeals, our administrative appeals body, looks at the state law. What would be the burden of proof for the state, for a prosecutor to show guilt of the defendant? For it to qualify as a conviction, one of the factors is, did the state have to prove guilt beyond a reasonable doubt? If the municipal ordinance violation only requires the local prosecutor to show a preponderance of evidence, it's not going to meet the definition of conviction. We also have, all across the country and in the federal system, recidivist statutes. So recidivist sentencing for prior convictions. So you have a client who is arrested for the second or the third or the fourth time controlled substance violation. Very often the penalties, the sentence, will be enhanced because of prior convictions. Well, one of the factors in determining whether a municipal ordinance violation or some sort of local disposition is going to qualify as a conviction is to look at whether or not that prior disposition can be used to enhance the sentence on a subsequent violation. Does the county, does the municipality provide for court-appointed public defender, for a court-appointed lawyer? If not, it may not qualify as a conviction. So what this slide is, what is the burden of proof? Can the disposition be used for a sentence enhancement? Is there a right to court-appointed counsel? These are the different factors, ladies and gentlemen, that you can look to and apply in determining whether your client's very minor marijuana disposition is going to qualify as a conviction under the immigration law. Now, I'm going to do the next slide. All right, across the country, many states, not all states, are making efforts, the prosecutor's offices are making efforts to sort of vacate and dismiss, clean up, expunge, ameliorate the marijuana convictions, not just for foreign-born people, not just for people facing immigration consequences, but for prior offenders who are now suffering disabilities because they have a conviction or maybe a couple of convictions for marijuana offenses. And as the states are legalizing marijuana, they're also saying, well, look, these are people who now have criminal records because when they were, in their college years, they possessed marijuana and they were convicted. Well, that also includes foreign-born defendants and immigrants and people that are either in deportation proceedings or they're applying for immigration benefits, and they have one or two convictions for simple possession of marijuana. And the states are trying to go back, open their files, and clean those records. Well, those rehabilitative efforts are very nice. Thank you. But sometimes they really don't help, and sometimes they actually make it worse. Why? Well, number one, when a client is applying for immigration benefits, very often they have the burden of proof. All right. Not in removal proceedings, but if you're applying for residency, if you're applying for DACA, if you're applying for a visa, if you're applying for citizenship, the burden of proof is on you to get all those records. If the record has been sealed or expunged, you physically don't have access to those records. Number two, and perhaps more importantly, substantively, immigration law does not recognize an automatic remedial or mitigating vacatur of a plea and vacation of a conviction. So if the prosecutor's office is rolling up their sleeves and going into their filing cabinets, and they're sort of automatically, without the defendant, without the offender doing anything, they're sort of automatically erasing that conviction, vacating the plea and erasing that conviction, it's not going to be honored by immigration law. And I'm going to let Caitlin tell you what's going on in New Mexico, and Caitlin, why immigration law does not recognize an automatic rehabilitative procedure.
All right. So this is other states and efforts that they've made as far as automatic sealing or expungement of marijuana crimes. Generally, simple possession under a certain amount. We are certainly hopeful that if legalization of recreational marijuana does pass in the next year, there will be something in that bill that also includes clearing out the records for those who have already suffered the consequences of these draconian marijuana laws. So right now, as you guys know, in 2019, we enacted a comprehensive law that authorizes expungement and sealing of most non-conviction records and of conviction records in all but the most serious and violent sexual crimes. And so now we do have a comprehensive expungement law here and sealing of records, which is great for everybody except for non-citizens. This is not helpful for immigration purposes. In immigration court, for immigration purposes, what you really need to be doing are filing petitions to vacate and set aside pleas and convictions, and you need to be doing this on constitutional grounds. We have some really, really great case law here for that. In State v. Paredes, the Supreme Court held that a criminal defendant's attorney has the duty to determine the client's immigration status and to advise the client of the specific immigration consequences of pleading guilty, and that includes whether or not deportation would be virtually certain. So it's not good enough to tell somebody there may be immigration consequences. You need to be extremely specific about it. Otherwise, that plea is not seen as voluntary and knowing. Another case that we have here is Ramirez v. State, and in this case, the Supreme Court clarified that advising a client that deportation is not a consequence when it's a possibility, or advising a client that deportation is only a possibility when it's virtually certain, or failing to give the client any advice at all regarding immigration consequences, including whether or not it would affect them in an application for residency or an application for citizenship, does or may satisfy ineffective assistance of counsel. So these are the cases that you really want to be looking at. If you have somebody come to see you about an expungement and they're a non-citizen, it's please consult with an immigration attorney, because expungement is not going to be helpful down the road for your non-citizen clients. All right, and this is Mary's.
All right, so to sort of build on what Caitlin was saying, the Board of Immigration Appeals and all of the circuit courts of appeal above the BIA have affirmed the BIA in order for a vacatur to be effective, you need to move to reopen the plea, and you need to do so based on statutory or constitutional legal defect in the plea. This cannot really be stressed enough, especially for those of you who are maybe going into criminal defense, or maybe you want to do a hybrid practice of criminal and immigration law. I know we have a lot of law students on, and I know we also have immigration attorneys. So I'm not exactly sure what is the split. So I'm going to try to reach out to both of you in my remarks. But it really can be devastating to a client to move to reopen and seal and find out later it wasn't done right. So under matter of Pickering, that's your case, that's your go-to case. You really have to file a motion to vacate the plea based on statutory defect, not advising of immigration consequences or constitutional principles, or both. And the judges and the immigration officers are going to want to analyze the motion to vacate, and they're going to want to see why a case was vacated. So if it's just for touchy-feely niceness because marijuana is not so bad, it's not going to help. Excuse me. And a sealed and expunged record is still there for immigration purposes. A sealing or an expungement really doesn't make it go away. And I tell criminal lawyers this all the time, and I tell clients, please don't seal and expunge, because you're just making my job that much harder, and you actually might not get the benefit that you want to get because you destroyed the record. All right. So one of the problems that comes up with moving to vacate your plea based on statutory or constitutional grounds is that a lot of states seem to have a 2-year deadline. Under the federal system, there's a 2-year deadline to come back and attack a plea. Sometimes you can get around that, and it sounds like prosecutors are also willing to do that, which takes us to the next slide. I don't know, Caitlin, if before we get into this topic, did you want to say anything else about prosecutors working with you in New Mexico?
Yeah, I mean, I know it varies by county, and I practice in Santa Fe, but what I've experienced here with the DA's office is that they're largely willing to work with you and may even be willing to join in your petition for a plea withdraw. And so it's a really good idea to reach out to them, sometimes showing them the positive equities your client might have. Maybe they haven't had any subsequent violations of the law and things like that. But also in New Mexico as a whole, I think our judges have really become educated on this issue, and we've seen many of these plea withdrawals be, very successful for our clients. And ultimately, these cases tend to be old, and so they don't re-prosecute them. Oftentimes, you do end up getting a dismissal. And so, especially for clients that are going to be applying for relief through USCIS, we have to disclose any arrests they've ever had, any charges they've ever had, but we also need to show the dismissal. So if you seal a case or you do an expungement, we don't have access to those records. We can't prove that this was dismissed or that it's not a conviction. And so it really ends up being a nightmare for the clients.
It's interesting. We will see what the new presidential administration does. And we're kind of, in a way, Caitlin, talking about two different things here. We're talking about old convictions, because even if you live in Colorado or California, or Oregon, you might still have an old conviction that is causing problems for you and is an impediment in deportation proceedings or in meeting your immigration goals, even though now the state would not have prosecuted that offense. And then we're talking about what states are doing nowadays. I'm in Florida. We have medical marijuana laws. Recreational marijuana is not legal. I'm originally from Wisconsin. I go back to Wisconsin a lot. Wisconsin has neither medical marijuana laws nor legalized recreational marijuana. But if you cross the border and you're in Illinois, go to Chicago, it's 2 hours away. All of a sudden, you're in an environment where marijuana is completely legal, for personal possession and personal amounts. So we will see not only if the Biden administration alters federal law's treatment of marijuana, but also if there's any solutions immigration-wise for people with prior convictions. Now, we promised you that we wouldn't only be talking about deportation and removability for marijuana offenses, but that we'd also be talking about inadmissibility. And I told you there are two chapters that deal with removability and deal with consequences, immigration consequences for crime. The other chapter is INA Section 212A, which is also known as 8 U.S.C. Section 1182. Now, there are several provisions at Section 212A that deal with marijuana type offenses. You can be found inadmissible for a visa or denied entry at the border, denied adjustment of status, have problems, we'll say, with your naturalization, or if you are someone who entered the United States unlawfully, or you're met at the border and placed in removal proceedings, you can be removable. So as compared to Section 237 of the INA, Section 212A has far more reaching consequences because it applies in different situations, all right? So it's a ground of removability. You can be denied entry at the border. You can be denied a visa. You can be denied adjustment of status, which is your residency, and it'll cause you problems for removability. There is a provision for people who abuse drugs and seem to have a drug abuse problem. There is a provision for people who have a conviction or admit to the essential elements of a marijuana crime. And I'm saying marijuana, but we're talking about all controlled substances when we talk about these legal provisions. But for the purposes of today, we're talking about marijuana. All right. There is 212A2C, people who have trafficked in controlled substances, including marijuana, or those who aid, abet, or assist them. Aid, abet, or assist. That, my friends out there who fish, is a very wide net, okay? That catches a whole lot of people who really do not consider themselves to be involved in trafficking. NIV and IV for you law students out there, non-immigrant visa, immigrant visa. All right, applicants at the consulates, adjustment of status, admission at the border. These are your provisions. Next slide. All right. Admission of the essential elements. Caitlin, is that you or me?
Well, I think that's you.
All righty. So a very old but well-used case is matter of K. That's from the Board of Immigration Appeals. And what it says is if you are going to be found inadmissible for admission of the essential elements, there's an analysis, okay? There are rules of the game. And that is that the individual has to have the elements of the offense explained to them. And they have to admit to each and every essential element. So it can't just be that there's an interview with an officer at the airport or an interview with a consulate officer, and then that officer sort of puts down, you know, he sort of admitted to smoking pot. No, it's not that vague. The actual criminal statute for possession of marijuana or unlawful use of marijuana has to be explained. The elements have to be explained, and the person has to knowingly and voluntarily admit. Next slide. So I hope, you know, you all are keeping up with that. When you are applying for residency, when you are applying for a benefit at the consulate, when you are trying to enter the United States, bottom line, even without a conviction or a formal arrest, if your client opens their mouth and admits to smoking pot once, they can be denied entry, denied the visa, denied residency. They're also, by the way, Caitlin, we didn't put this on the slide, mandatory detention, no bond. mandatory detention. This is the state of federal law right now. This is the state of our immigration laws. There is just no mercy, no room for violation of marijuana laws. And if you admit to the essential elements of a crime, I sometimes call it, if you confess, even without an arrest or a conviction, you can be denied entry, you can be placed in removal proceedings, you can be denied the visa. All right. How does that work? Well, anecdotally, the Seattle Immigration Office has a form that sometimes, not always, sometimes, I don't know who came up with this, a grumpy, mean officer, that you swear that you are filling it out under penalty of perjury. You're filling it out voluntarily. And then it's like, have you ever used marijuana? Have you ever possessed marijuana? And if you want the benefit, if you want residency, you have to fill out the form. And once you sign it, they deny you residency. Next slide.
And we haven't seen that in Albuquerque yet, but keep in mind that it could happen.
Yes. All right. Now, this is just a reminder that whether or not a controlled substance, marijuana, is going to be lawful under state law has no relevance to the immigration situation. And marijuana is defined at 21 Code of Federal Regulations, and it's defined in the Controlled Substance Act. Now, you see down there at the bottom of the screen, 9 FAM 302.4-2. For you students, FAM is the Foreign Affairs Manual, and it's kind of like the policy guidelines, but more than that, it becomes like a type of federal regulation for all of the American embassies and the consulates who are issuing visas abroad. So that is a provision, volume 9 of the Foreign Affairs Manual. And there you see how the State Department defines marijuana and their instructions, and we're talking about the embassies, their instructions to their officers that it's completely irrelevant if that state makes marijuana lawful. So if you have a client, whomever it might be, we'll just say, Julia, and Julia goes to the American embassy in, I don't know, Lima, Peru, and applies for a visa. And in the course of that interview, for whatever reason, whatever comes up, maybe something alerts the officer to Julia being a little bit odd. Maybe her eyes are red. Maybe she has the aroma of marijuana on her, whatever. Certainly there doesn't need to be any probable cause for the question. Maybe, and we're going to talk about this, maybe she has a DUI arrest or something that indicates she's a partier. If she admits that last week she smoked marijuana in Oregon, well, that is a violation of federal law, even if it's lawful in Oregon. They're going to look to this provision, volume 9 of the FAM, and they're going to deny her a visa. She's inadmissible. She's inadmissible. Let's say, Caitlin, let's even bump it up a bit. Let's say Julia has a medical marijuana card. And she says, yeah, I have a medical marijuana card. I have a lot of anxiety. It's lawful in Oregon, and I use marijuana and chew the gummies in my garage of my Oregon home. She's going to be denied a visa. Next slide. All right. The panel physician, and now, especially immigration attorneys, listen up. Most of you know that in applying for adjustment of status or an immigrant visa, there's a medical exam, and the medical exam has to be performed by a certified doctor. That is not what we're talking about. The panel physician is sort of an independent contractor or contractor on contract with the consulate abroad, wherever that American consulate might be. I don't think there's a lot of them. I think there's probably 2 or 3. This is not your certified medical doctor for purposes of an immigrant visa or adjustment. This is a panel physician, and they work for the consulate, but you're gonna be paying the cost. The consulate, whenever something goes off in their mind and doesn't seem right, ding, 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 you know, they have a concern about a significant contagious disease, or maybe a couple of DUI arrests, which lead them to believe there might be an addiction, anything like that. They can send a visa applicant. We're not in the United States anymore. We're in Lima, Peru. They can send a visa applicant to a panel physician for an interview and examination. You do not have a right to that doctor's notes or the results. The results go directly to the consulate, and you will never see them. Feel free to file 100 Freedom of Information Act requests. You're not going to get the panel physician's report. A DUI arrest frequently leads to someone being sent to a panel physician. Again, depending upon the profile of the person, I don't know, they might not ask me. They might ask you, Caitlin, you're much younger than me. You know, the panel physician can say, you know, hey, how about, you know, those college parties and smoking pot? Remember the good old days? Or do you ever use any weed? You know, and they can even cozy up to you, get you to open up. Oh, you were arrested for DUI. Did you have marijuana that night too? Blah, blah, blah. And those results, those private, confidential, sealed, there's no HIPAA, okay, in Lima, Peru. They're going over to the consulate officer, and you can be denied a visa. So what is the point of my rant? Attorneys need to really, really prepare their clients for the panel physician interview very, very defensively. And there are ethical issues that we are not going to get into, that Caitlin and I voted, and it was unanimous. We're not going to get into heavy duty ethics, right?
That's a whole nother CL, you guys.
But, you know, how do you advise your client? I usually will tell my client, look, what you choose to do is your decision, and it's up to you. But if you admit to using marijuana even one time, you're going to be denied a visa. That's the law. Do with it what you will. I don't know if you want to add anything to that, Caitlin.
Yeah, I mean, I had a client who unfortunately did fall into the trap and admitted to past marijuana use, not current marijuana use, despite being very well prepped for this. He ended up being denied a visa and was actually stuck in Mexico for a full year before we were able to go through the process and try again. And a year of family separation is obviously something very, very serious. So you want to be sure that your clients are very well prepared for this, and that they realize that, hey, I smoked a bunch of weed in high school, can come back to haunt them.
Mm-hmm. Yep. Should we go to the next slide? All right. That was the ethical slide.
Do you want to keep going?
Yeah. Next.
Testimony.
All right. Oh, can we go back for a second?
One more? This
No, right there, right there. I think all of us as law students and attorneys probably have a great deal of respect for the recovering addict, the recovering alcoholic. I sometimes, Caitlin, just stand up in my office and I say, you know, I honor you. When a client tells me that they have struggled with addiction, but they're in recovery. And I think that's very, very impressive. The immigration law and many, many officers don't find it impressive. And if a recovering addict or alcoholic says, I'm in recovery, I used to have a problem, I don't anymore, they're going to be denied a visa. Next slide. I hate to laugh. That was nervous laughter. Okay, so practitioners, keep this in mind. If you are at a plea hearing and you're engaging in the plea colloquy, you really want to specify that the amount of marijuana involved was less than 30 grams. That's very, very important to preserve the record. Next slide.
I know we've got about 5 or 10 minutes before questions.
Oof. Okay. So immigration law takes the categorical approach, which unfortunately is going to take 5 hours. So somebody, maybe Christina, needs to call Zoom and get more time. Just kidding. All right. So
I'll put my email
approach,
for
the categorical approach is where you take your client's statute of conviction, the statute they were convicted under, and you compare it to either the federal statute or some sort of generic analog, generic crime. We find that sometimes states define marijuana differently. They define what is marijuana differently than the federal statute. And a good case to look at is matter of Navarro Guadarrama, which actually came out of Florida. The Florida statute is very broad. It includes the whole plant. It includes some of the dirt, whatever, and it's much broader than federal law. And a very good creative attorney argued, well, my client's marijuana conviction is not actually a marijuana conviction because Florida defines marijuana more broadly than Florida law. And the Board of Immigration Appeals came back and said, well, yes, but applying then the next step, which is a realistic probability analysis, realistically, prosecutors in Florida would never charge all those miscellaneous portions of the plant and convict someone for possession of marijuana. Next slide. So then here you see 21 USC, the definition of marijuana. It's, many parts of the cannabis plant, but it does not include hemp, the mature stalks of the plant, fiber, oil, or cake, the sterilized seeds, which are incapable of germination. So that takes us to New Mexico, right, Caitlin?
That's correct. So you can find the definition of marijuana. I put the statute here for you. It's similar to the federal definition. It also does not include mature stalks, hashish, things that are extracted, fiber produced, oil, cake, seeds, compounds, but it very much tracks the federal definition of marijuana.
So for those of you representing people who have convictions perhaps outside of New Mexico, you might want to, as a first step, compare the state definition of marijuana to the federal definition. And you might have an argument, not only in immigration court, but in front of USCIS or the consulate, that it really should not count as a marijuana conviction. Medical marijuana is the next slide. All right. So medical marijuana is not okay. Again, federal law does not recognize any justifiable medical purpose or legitimate medical purpose to marijuana. I do not have a marijuana card. I do not know anybody who has a marijuana card, or I probably do know them, but I don't know they have a marijuana card. But so I don't know exactly how the databases and the registration and the card works. But for clients from Canada, Customs and Border Protection, USCBP, has access to the medical marijuana users database in Canada, and they know who's registered. And those people can be pulled over and found inadmissible. So if you have a client who is somehow registered in a database as a authorized medical marijuana user, you need to stop and consider, does federal law enforcement or immigration officials have access to that database, or will they ask for your permission to gain access to that database? Or will they ask your client, are you registered in that database? Another issue, Caitlin, we were talking about 212A2C and reason to believe drug trafficking. And I pointed out it's not just the drug trafficker, and it doesn't require a conviction to be found inadmissible. It also includes people who aid, abet, assist. There's like 8 verbs there in that provision, okay? And what we have found, and we know to be true based on our committees and our national emails and listservs and, communication amongst attorneys, is that clients who are like the accountant for a medical marijuana business, a legal medical marijuana business in Canada or wherever, in Europe, accountants, web designers, anyone who is at all involved, even tangentially, in the medical marijuana business can be found inadmissible for aiding and abetting drug trafficking. So when you work with clients, you really need to go over what it is that they do. Are they an investor? That's a big one. Do they invest in medical marijuana businesses? Because Customs and Border Protection, CBP, will deny entry to people who are in any way affiliated with an otherwise legal, legitimate medical marijuana enterprise. Next question. Next slide. All right, that can lead to expedited removal, which is when people are turned away at the airport or the land border. They are turned away and removed, and it's an order of removal. It doesn't come from an immigration judge. It comes from a CBP officer. But people are, and again, a lot of this is anecdotal, but more than anecdotal, we know this to be true because attorneys are communicating with each other and through committees and practice advisories. But anyone who is at any way involved and certainly investing in a medical marijuana enterprise, it can come out at the port of entry and they can be removed, and then they lose their visa and they got an order of removal. Next slide.
All right.
That. Questions, comments, and
I'm gonna
experiences.
stop my screen share so we can have a discussion. And I'm gonna put my email in the chat in case anybody has questions we don't get to.
So I welcome people to put your questions in the chat so that our presenters can answer your questions right now. So while we're waiting for, I guess I see some of my students and ex-students in our session today. So please put your questions in, because otherwise you're going to have to listen to me, and you know I ask terrible hypothetical questions, but I'm going to go ahead and start. So Caitlin had said, and I'm not sure if I have this right, but I think Caitlin had said that the prosecutors in Santa Fe are willing to work with the defendant immigration attorneys on plea withdrawals for old convictions. I'm wondering though, what about at the trial phase? When you're working with a district attorney and you're really trying to avoid that drug conviction, do you say something to the DA about, like, I'm really trying to get this plea for my client, or withdrawal, would really help out my client, I mean, like with a wink? Or do you actually say, like, it's an immigration thing, so can you work with me here?
I mean, I've always called up the DA and, been very real about it, that, this person is a non-citizen and this conviction could possibly result in removal, family separation, could really ruin their lives. And a lot of times the prosecutors are even willing to knock down the charges a bit so you can get that plea down to a possession of under 30 grams of marijuana so that their immigration situation could be salvageable. Obviously, this doesn't work for all crimes, but because attitudes here about marijuana are really changing and becoming quite progressive, I think it's absolutely worth it to reach out to the prosecutor and let them know what the situation is and see what they'll be willing to do as far as working out a plea or an agreement that can avoid serious immigration consequences.
Thank you. I see we have a question in the chat. How can juvenile marijuana violations affect future immigration benefits?
That is a great question, and it's actually kind of a high-end complicated answer. So acts of juvenile delinquency adjudications are not convictions for immigration purposes. That leads us, though, to the question of what about admitting to the essential elements of a crime such that you don't have a conviction, but you've admitted to marijuana usage as a juvenile. And if you research, and there's a ton of research out there, the basis behind juvenile delinquency adjudications and the fact that juveniles don't really commit crimes because they don't have the mental capacity to form intent. They are not physically, and this is the research, and I'm far from a medical doctor, but there's tons of legal articles and discussions about juvenile delinquency. Juveniles are treated differently in our criminal justice system because they don't commit crimes. They are delinquent, they're acting badly. If you can form a legal argument in a memo in support of whatever benefit you're seeking, arguing that an act committed by a juvenile should not be held against them, I think you are able to succeed in getting the visa, getting adjustment of status. And I have done that. In my book, I have a discussion about acts by juveniles, not just juvenile delinquency convictions or dispositions, but acts committed by juveniles and why they should not be punished under the immigration laws.
Okay, thank you. Next question, is there any deference to an immigrant's home country's laws on marijuana? For example, if I am from Belize and medical marijuana is legal in Belize, does the Border Patrol pay any deference to the fact that when analyzing my past marijuana use?
I would say no, not at all. I mean, they don't pay any deference to whether or not it's legal in your home state either. It's, it's contrary to federal law. And I mean, Border Patrol officers aren't the nicest people always either. So I would definitely say that would not come up. I don't know if Mary, if you've heard anything differently, but I don't think so.
No, I agree with you 100%. And it's a great, great question. And it shows you what kind of catch-22 trap we are in. But immigration laws always look at what we call a federal analog. Everything with immigration is comparing that offense activity first and foremost to the United States Federal Code. If it is a crime that would normally be punished by a state, the analog is the Washington, D.C. Criminal Code. So immigration law, because it takes a categorical approach, is always looking at the generic crime. And the generic crime, again, federal law, the federal code, the Washington, D.C. Criminal Code is what foreign convictions are compared to, or a compilation of case law and sort of common law as to what the generic crime would and should be in terms of its elements. So it doesn't matter if Belize allows for simple possession of marijuana and recreational use. It doesn't matter if Oregon does. It doesn't matter if Illinois does. We're looking always at federal law. So it's what was the person's activity? What were they doing? What happened? And how would that be treated and viewed under federal law, under United States federal criminal law? But great question.
Those are great questions because they're not from me. So someone else want to ask another question in the chat? We might have time for one or two more. But in the meantime, I'm wondering, do you think with this new administration, do you see any sort of changes on the horizon or advocacy on the horizon to advocate for change?
Well, I think that personal possession of marijuana is going to be decriminalized at a federal level. I don't know for sure, but the House took up a bill on this the other day and it passed. And I think either Biden or Kamala Harris had as part of their platform. But what are we going to do? Carol, what are we going to do about all the old convictions? And, and that's the issue. If the states and federal law go through and just like, oh, they're automatically reopened and wiped out. Well, at the same time, they need to tinker with immigration law because the state or prosecutor's office automatically vacating and eliminating a conviction for rehabilitative, warm and fuzzy reasons is not going to help with immigration law unless immigration law and policy is simultaneously modified, that sort of ameliorative procedure would count.
I have another question from our collaborator, Jessica Miles. So just to be clear, less than 0.5 an ounce is not a regulatory in New Mexico, correct? So does that mean that is not an inadmissible offense because it does not qualify as a conviction?
I think that also would depend on whether or not you're applying through CIS or consulate. But certainly here, now it is a $50 fine. It's a traffic citation. You would not be able to get a public defender. You don't even get a court date with that offense. And so I think there's certainly very strong arguments to be made that it's not a conviction. But when you're doing a consular processing case, at that point too, then you get into all of these other issues of reason to believe, do you admit your marijuana usage, etc. I don't know if Mary has anything to add on that.
No, I agree with you. It's more for a New Mexico lawyer.
So yeah, I mean, I think it depends on which door you're knocking at. Certainly, there are many exceptions also as far as inadmissibility. If it's less than 30 grams, you can file a waiver, and there's other avenues for relief. But I wouldn't say that it is a total get out of jail free card either.
Okay, thank you. Oh, and thank you, Jane. New question. Marijuana is strangely a Schedule I drug. How can this be changed, and what effect would that have for convictions?
Well, I think we would have to change that through legislation, and certainly at the federal level. I mean, my hope is that that will happen at some point, although we seem to be very slow to progress in this country. And I think, as Mary had said earlier, both immigration law and the federal controlled substances laws would have to change together. I don't know how other people feel about this. I would love to see comprehensive immigration reform. We haven't had that since the 90s. Do I think that's going to happen anytime soon? I don't. Maybe if we can take over the Senate, I don't know.
I have a question about, you said that the U.S. government has sort of information about cannabis dispensary owners or people who run them in Canada. Does that include like people who invest? So who are like silent partners, but who invest their money?
I don't think it does. I don't think it does. But when you are coming in at a port of entry, a CBP officer can stop and ask you what it is that you do. And it's like a lottery every time you come in. Some clients are almost never stopped. Some clients are stopped frequently. It's like when any of us go through the little security door and sometimes it beeps, and then they say random check, and then we're delayed for our flight. So if an immigration officer has any reason, maybe even slow day at the airport, to stop and ask a person what they do, and the investment comes out, they've got a problem. But I don't think that CBP has either the time or the resources to know what people invest in or what they do. Keep in mind, CBP can take people's phones. They can look through their social media. The question is anything going to happen to spark their interest in your client and cause that to happen?
Okay, thank you. So I would like to thank Mary Kramer and Caitlin Ford for your presentation, and your update today is very informational. And thank you for everyone who has attended the CLE. Please submit your CLE form and to Cheryl Burbank. I hope that's correct. And we will have some end of the year recorded CLEs on December 28th, 29th, and 30th, if you still need to finish up to get some more CLEs for the rest of 2020. So thank you, everyone. Please take care, and we hope to see you.
Thank you,
maybe-
Professor.
Yes, thank you.
Thank you.
Oh, return your form to Emily Johnston in the chat, her email address. Thank you, Emily.